morning, everybody, and thank you for taking time out of your schedule to join us today. I'd also like to thank the Securities Commission for arranging this industry update on the Investment Funds Act. We've been working with this legislation for just over a year now, so I think this is very timely. We're fortunate enough to have with us Michelle Martinburr, Senior Legal Counsel, Megan Taylor, Manager of Supervision, and Christina Roll, the Executive Director. We'll start with Megan Taylor, who I think we'll all be happy to hear. We'll be walking through the new investment manager registration process, which is new to us, so we appreciate that. We'll then move on to Christina Roll, who will go over some of the different policy issues that have arisen and address the manner in which the Securities Commission is addressing them. After that, everyone is happy to take any further questions, and this is a good time to do so because if there will be any amendments, let's hear what the issues are so they can be addressed as best as possible by the Commission. Megan?
Greetings all. Good morning and thank you for joining us for the first industry update for 2021. The investment funds industry has seen several changes in the past 2 years, and it is therefore important for us to provide timely information and updates on the current funds industry and its development. My presentation today will cover the investment funds activity over the past year, provide a review of the investment fund manager registration process, and lastly, highlight and briefly discuss trends, concerns, and developments within the funds regime. 4 new pieces of legislation came into force in 2020. They include the Investment Funds Amendment of 2020, the Investment Funds Regulation 2020, the Investment Funds Prescribed Jurisdiction Rules 2020, and the Investment Funds Fee Rules 2020. The fee rules were revised in December of 2020 to reflect a slight increase, and licensees are reminded to take note of those increases when remitting application and license fees. While there are a few matters to be amended in the regulations, we do anticipate that by the end of the third quarter of 2021, the legislation will be completed. Of note, the continuing obligations for administrators and funds remain in place, including the payment of license fees, specific filing requirements, financial reporting, and material change reporting. With the time period for the registration of existing fund managers being extended to the 31st of January 2021, fund managers with applicable annual renewal fees and filing requirements, i.e. the annual declaration, are expected to comply fully in 2022. The 10th schedule of the Investment Funds Regulations 2020 prescribes the administrative fees for non-compliance, which will be strictly applied. In spite of the global pandemic, over 745 applications were submitted to the Supervision Department under the IFA regime. This number does not include the director applications, changes in service providers, approval of auditors, and change in categories for investment funds. The bulk of these applications related to investment fund managers, making up a total of 439 for the year 2020. The second major category of applications involved extension requests for audited financial statements, which due to the pandemic were disrupted. The Commission will be carrying out a compliance and penalty exercise for audited financial statement submission for financial statements which are outstanding and will have further discussions with funds which continue to experience delays. In terms of the submission of audited financial statements, there was only one instance of failure to submit audited financial statements within the statutory time or within an extension period by a fund administrator in 2020. That unrestricted fund administrator was penalized to the maximum extent permitted for failure to submit 2017 and 2018 audited financial statements after failure to comply with the final extensions granted by the Commission. Through continuous communication and meetings with the auditors for the UFA, a timeline was given and the issues were addressed. In the third quarter of 2020, the IFA unit, the Office of the Executive Director and Legal Counsel, met with the members of BICA to discuss revisions to the audit extension policy and limiting the number of extensions for submission. BICA presented valuable views concerning current challenges in valuation methods and underlying assets, along with another issue relating to the regulations. It is our intention to complete this work to the extension policy to address funds with valuation difficulties and increase our monitoring of fund performance and financial reporting. With respect to penalties in 2020, 45 funds were penalized for the late submission of annual license fees for a total sum of approximately $77,000, and 3 administrators were penalized for a sum of approximately $39,000. In 2021, 41 funds were penalized for a total of approximately $94,000 in penalties, and 1 administrator was penalized in the sum of $13,500. I would now like to review the registration process for investment fund managers. Pursuant to Section 24 of the Investment Funds Act, an investment fund shall appoint an investment fund manager upon commencement of operations as a regulated investment fund. Where an investment fund appoints an investment manager, the investment manager shall be required to be registered pursuant to the provisions of the Act. Section 26 further provides the requirements for those persons who can act as investment fund manager for standard, professional, and smart funds. Before I go through the registration process, I will address 2 frequently asked questions in relation to the IFM regime under the IFA 2019. The first question is, do all smart funds have to appoint an investment fund manager? The answer is no. However, where a smart fund has appointed an investment fund manager, that manager should have made an application to be registered by the 31st of January 2021. Where a smart fund is licensed after the 31st of January 2021 and appoints an IFM, that IFM should not act unless registered under the IFA 2019. For funds licensed by an unrestricted fund administrator, the registration of the fund manager should be submitted with the fund's filing. Question 2, is there a regulatory capital requirement for investment fund managers? Currently, there is not. Currently. However, where an investment fund is licensed or registered in any jurisdiction and subject to regulatory capital, that amount should be confirmed in the application process. We do anticipate that the form for investment managers will be expanded with amendments to the IFR 2020. The registration process is not meant to be exhaustive, and it is designed to supply the Commission with key information, such as the contact details and address of the investment fund manager, due diligence on the entity or individual acting as investment fund manager, the current standing of the manager, and to ensure that the fund's constitutive documents are in line with the person or entity conducting the fund management. Those persons who have completed or whose applications are in final stages of processing will note that officers have sought confirmation of the CEO, compliance officer, MLRO, and individual or individuals providing these functions or providing the investment management to the fund in the case of the company. Once the application has been received with the applicable application fee, a review of the documents of the fund will be conducted to verify compliance with any applicable law. Should any deficiencies be identified therein, the applicant will be notified and required to make the necessary amendments. Failure to comply with the Commission's directives may result in disciplinary action being taken against the applicant. The due diligence that should be provided with the application should include, for an individual, the CV, passport, or national identity card, utility bill, financial reference, and copies of qualifications. For a company, the certificate of incorporation or equivalent, certified copies of memorandum and articles of association, the register of directors and shareholders, evidence supporting the investment fund manager's licensing or regulation with the regulatory body, evidence of current standing with the licensor or regulator, confirmation of regulatory capital where applicable, confirmation of professional indemnity insurance where applicable, and the nature of the fund manager's business. Where the Commission thinks it's necessary to do so, it shall seek to verify the due diligence information submitted on the applicant in order to ensure that it is complete and satisfies the Commission standards. In this regard, the Commission shall consider that due diligence information is complete if it complies with the provisions of the Financial Transactions Reporting Act 2000 and any guidelines for the investment funds and securities industry published by the Commission. Again, disciplinary action may be taken against the applicant in the event that the Commission is made aware of any information bringing into question the fitness of an applicant or any misrepresentation during the registration process. Concerns and ongoing trends. Among the unit's concerns are incomplete applications, particularly for the fast-track process and for those funds licensed by an unrestricted administrator. Fast-track applicants should not rely on being granted an approval in principle, but should always ensure that the application is submitted complete. Additionally, we have noticed that applications for approvals of individuals are missing due diligence information and the resolutions making the appointment. All due diligence must be completed before an application is submitted to the Commission for approval or before a fund is licensed by a IFA. In the case of unlaunched funds, administrators and operators should take note that among the changes to the regime, the IFA amendment of 2020 amended Section 21(2), which provides that an investment fund that has not commenced its operations within 6 months of licensing shall surrender its license to the Commission. The Supervision Unit will monitor compliance with this provision, and notices will be sent to funds or administrators who are required to take this action. Additionally, the Act was also amended at Section 22 for suspension. Suspension of a fund, which differs from suspension of subscriptions and redemptions, is applicable only within 1 year of licensing. Licensees are encouraged to familiarize themselves with the provisions of Section 22 for voluntary suspension of a fund. Lastly, licensees are reminded to comply with the submission of performance reports for smart funds where applicable. The Commission will ensure compliance during both on-site and off-site review of entities. As funds submit applications for approval of directors, changes in the fund, and surrender or liquidation, outstanding performance reports will be requested for compliance. Among the supervision priorities for 2021 across all legislation administered by the Securities Commission, corporate governance practice was identified as an area which can pose systemic risks to the local financial services sector if the principles of corporate governance are A, not sufficiently comprehensive, and B, more importantly, not adhered to, as well as possibly exposing the entity to regulatory, legal, and reputational risk where the corporate governance framework is weak. Due diligence refreshers and desktop reviews will be conducted throughout the year 2021 for administrators to address areas of weakness. The Commission intends to finalize revisions to the IFA 2019 and IFR 2020 to remove several of the reporting obligations where fund managers and administrators were unintentionally captured, as well as to revise the fund administrator and the fund manager declarations. We will also revise the fund manager application form to reflect several of the suggestions and lessons learned during the initial registration exercise. With respect to smart funds, the Supervision Unit, along with the Executive Director and Senior Legal Counsel, began consultation meetings with administrators for several models of funds. The first meeting took place to address Smart Fund Model 1 concerns. It is anticipated that at least 2 more meetings will take place with the remaining Model 3 and 6 administrators, as well as with members of the Bahamas Financial Services Board Funds Working Group as we revise the Smart Fund rules. Lastly, licensees are reminded of the upcoming deadlines for audited financial statements. Where an extension is required, in order to avoid a penalty, the request must be made 7 days before the deadline for submission of the audited financial statements. As there are only 2 extensions for audited financial statements, you should seek a realistic but not inordinate time period for submission and provide as much detail as possible with respect to the reason for the extension to avoid us seeking clarification of your request. We do anticipate that once the regulatory interface functionality is fully achieved, the newly designed application form will streamline our review for more efficient processing of extension requests. The statistical information filing request was sent out on the 25th of February 2021. If you did not receive this request to your inbox, please review your junk mail or contact myself or a member of the team to forward the same to you. As we suspended the request of this information due to the COVID-19 pandemic last year, please ensure that you provide the NAV information for all of the periods requested to assist with our collection of important information on the activities of investment funds to understand the development of the market. Your cooperation is encouraged, and we are here to assist you with any clarifications you may require. Thank you for your attention. I'll now hand the presentation over to Ms. Christina Rowe.
Thank you, Megan. I know there's some questions, but we will wait until after Mrs. Roll's presentation to address them. I know you frightened me when you kept stressing currently no regulatory capital, but we will hold the questions to the end of Mrs. Roll's presentation also.
Thank you, Michelle. Thank you, Megan. I want to say a special thank you to Megan, who took on the investment funds unit about 2 years ago. And since that time, you know, the legislation was new, but since then she's really embraced it as her own. And she's really running with matters at a level that I can only say we're pleased at the commission that she's with us.
Thank you.
Okay, so I probably won't be as polished as Megan, but I think that what I'm trying to achieve here with this presentation is to really go into the details of some policy issues that we have been addressing since the legislation was implemented a little more than a year and a half ago. And certainly these are issues that are recurring. You'd see 5 of them placed up on the screen, and those 5 are probably what I would call the big 5 issues that mostly lawyers and administrators have been writing into the commission to address. So I'll just go through them one by one. And so the first issue to tackle, of course, is the independence of the directors. So just to give those of you who may not be very familiar with the issue a little background into it. So the issue comes up in Regulation 76 of the Investment Funds Regulation 2020. And so, and I'm going to try to do this by memory, but the way the regulation is structured, in 76.1 says basically where there is a unit trust, the investment fund administrator should be independent of the operators, the investment fund manager, the custodian, the AIFMD custodian, et cetera. And then it says that they can be deemed independent under Section 76.5. 76.2 then goes on to say that where an investment fund is a company, an icon, or a partnership, then the operator must be independent from the investment fund administrator, investment fund manager, custodian, AIFM custodian, et cetera. And then it says, unless they are specifically exempted by the licensor. So 76.2 creates a scenario where a licensor can exempt from this independence requirement. And then it also goes on to say, or they can be deemed independent under 76.5. I think in 76.3 just basically makes a carve out specifically for the icon in recognition that the administrator and the operator may not necessarily be independent of each other and gives that carve out. I think 76.4 then addresses self-administered funds and really says that Section 1 and 2 don't apply to them. But then we have to the big issue in 76.5 of who can be deemed independent. And so therein we have a couple issues in the legislation that we probably will need to seek to fix. But first, I want to talk a little bit about 76.1 and 76.2. And really, when we've reviewed this matter internally, and I'm going to do something here that I know we in the Bahamas are used to people doing, but I'm going to admit that we perhaps were wrong. But we noticed in 76.1 and 2, we made a distinction between a unit trust as a type of fund and as a fund structure and a company icon or partnership. And really, there's no need for that distinction to take place. So really what you are likely to see in the future is a combination of 76(1) and 2 really just addressing where there's an investment fund, then they should be independent of each other. And then the issue will be whether the licensor can exempt that investment fund, whether it's a unit trust or a company or ICON. And the short answer will be yes, we will leave that provision in there for any type of fund structure, and then we'll also leave the deeming provision in there. So then we come down to this deeming provision, which creates quite a bit of headache for all of us. Even us at the Commission. What the regulation says now with respect to the deeming of independence, it says where the investment fund administrator, operator, custodian, and the AIFMD custodian are companies with the same parent company, the investment fund administrator, operator, custodian, AIFMD custodian shall be deemed independent of each other where A, they are subsidiaries of a financial institution, and then there are some other things that I don't think I need to read all of the details of that. But we do recognize the problems that have arisen as a result of this. And what we see as the solution to the issue is we will make an amendment to 76(5), and the new amendment, after the amendment, it will say the investment fund administrator, operator, custodian, and the AIFMD custodian shall be deemed independent of each other where A, they are subsidiaries of a financial institution or entities with the same parent company. So that will fix the issue of the deeming. The other issue, though, that it won't fix is this scenario where someone can be specifically exempted by the licensor. And so the issue will become, under what circumstances could the licensor exempt, and the licensor being either the Commission or an unrestricted investment fund administrator. So what are the circumstances where they can exempt a fund from this independence requirement? And so what I would say to that is that we're still thinking through our thought process on that, but what you will likely to see happen is we will likely to say that in circumstances where, for example, sufficient Chinese walls may be in place in the entity, so that will then be a judgment call on the part of the licensor. And you know, when we're thinking through this issue, certainly if you have big entities who, like for example, a Goldman Sachs who may be acting in both the capacity as the administrator and the investment manager, certainly we can appreciate that that entity would have enough Chinese walls in place that those functions can be deemed independent of each other. And so that is probably what, well, exempted as independent, not deemed independent. My legal counsel won't like that. But they will be exempted as independent. And so those circumstances, we're certain the Commission can live with them. And so I think we just need to flesh it out a little bit more in that direction. Okay? Okay, so then the second issue that comes up is the appointment of fund managers by smart funds. And so here we have a little bit of what we don't think it's as thorny as it became, but certainly I think one of the questions, the way we had a question posed to us was by what authority the Commission have to say that a smart fund doesn't have to appoint an investment manager. Well, okay, so let me try to work this out. Hopefully we do have the authority. I'm not saying yet we have the authority, but we think we do. So let's start with Section 6 of the IFA 2019. And so Section 6 says that notwithstanding Section 5, a professional fund or a standard fund shall not carry on or attempt to carry on business in or from the Bahamas unless it has appointed an investment fund administrator and an investment fund manager, or AIFM, okay? So that's clear, okay? You have to appoint one if you're a professional or a standard fund. Conspicuously missing from that is the smart fund. Now, what I will say here, and just stick a pin in it, I think we also meant to exclude the professional fund from this clause, but I'll get to that point later on, maybe. But definitely what is missing is the smart fund from here. So then if you go down now to section 7, where it speaks to the smart fund, it says, notwithstanding section 5, a smart fund shall not carry on or attempt to carry on business in or from the Bahamas unless, and then it has a couple things that they must do. But what is missing from here is that it's not saying that a smart fund has to appoint an investment manager. So I think in those two clauses, the intention of the act is very, very clear, that the act is not intending to impose a requirement on the smart fund to appoint an investment manager. Now, where does the problem arise? So I think the problem starts in 24. And in 24.1, which says, subject to subsection 3 and section 26.1, an investment fund shall appoint an investment fund manager upon commencement of operations as a regulated investment fund. Okay, so I would say here that, okay, maybe we can make that a bit clearer. But when you already have the intention established in 6 and 7, I don't think that this clause, badly worded or not, establishes the intention or creates an obligation for a smart fund to have an investment manager. And then, and so you can go through the other things, what they have to do. And then it says in section 26, and I think I have a section 26 here. And so the 26 sets out then the requirements for registration of an investment fund manager. So what we're saying between these 4 sections isn't that a smart fund must appoint an investment fund manager, but when they do appoint an investment fund manager, then they must meet the requirements of registration. And I think somewhere in 26, you would notice that whereas a standard fund has an obligation to have a fund manager that is licensed, a smart fund or a professional fund, and that is why I say a professional fund was probably meant to be excluded from section 5 as well. And that's probably something we just need to fix. But a professional or a smart fund or any other, a professional or smart fund can have a fund manager that is simply registered under this act. So they don't need a fund manager that has, that is subject to a full regulatory regime. Okay? So I hope that covers that sufficiently. The next issue that comes up, and this one came up fairly recently, but I think that it's a question that's worthy of consideration for the Commission. It's really simply something we didn't consider, and even with the years of consultation and review, we just didn't consider this question and the way it's posed. So the question is, can an investment fund manager be registered under the IFA without having been appointed to an investment fund? So you could imagine that for us, prior to looking at this, we didn't think of a scenario where someone would want to do this. You know, we would say, okay, you want to be registered under the IFA, surely you have been appointed already to a fund or you intend to be appointed to a fund. But I think what we recognize is there is a scenario where someone may be in a stage of being appointed where the operators of the fund will very likely want to know, and very legitimately, validly want to know, is this person we are about to appoint, can they get an approval from the Commission? And so the short answer to the question, can an investment fund manager be registered under the IFA without having been appointed? The short answer is no. Unfortunately, it just wasn't something we considered, and the Act, as it is currently written, doesn't provide for it. Now, the longer answer to that is what the Commission can do is the commission can, and we've undertaken in the instances where we were approached on the matter, we can provide an approval in principle. And that is our intention. And so the approval in principle is a stopgap measure where we can give an indication to an investment fund manager that yes, if you make a submission, provided that you are able to pass through the commission's due diligence based on what we've seen, we don't have any concerns, and it's likely that we'll give an approval. And so that, in that way, they can go out and they can say to an investment fund, yes, look, I would likely be approved by the commission. You know, they don't have any adverse information against me, or they're not adversely predisposed. And so what I would say, though, is that this is perhaps a question that we will be looking at over the coming weeks. And I think really before we can answer what legislative amendments we want to make here, we first have to answer the questions for ourselves internally as to whether this is something we want to provide for. And I don't think we've gotten to the point where we've fleshed that out entirely. But that is something we have committed to doing over the next few weeks. And so that's something certainly that we would pursue. Okay. Okay, and so these now are just a couple of short questions. And so with the treatment of foreign fund administrators, and I think this is one of Michelle Neville-Clark's questions, what is the SCB's intent regarding the treatment of ongoing reporting obligation for foreign fund administrators? So presently, we have a little bit of a boo-boo in the regs, and I think presently the ongoing obligations for foreign fund administrators are the same as those for restricted or unrestricted investment fund administrators. So certainly, let me just say unequivocally, that is not the Commission's intention to impose such ongoing obligations to the foreign fund administrators. However, we must rationalize the position and then make the amendments as necessary. Because, you know, it's certainly not our intention to impose any regulatory requirements on entities we do not regulate. And if you've been coming to any of these consultative meetings with us, you know, we have always been very, very clear on that point. So that's something we will rationalize and make the necessary amendments. And I think there is something similar Megan alluded to in her presentation with respect to the investment managers. Also, we must rationalize the ongoing obligations for investment managers. And so I think you can see that those issues being cleared up probably before the end of the summer. And then I think this may be the last question. Yeah, that's the last question. So why is an auditor required to be approved by the Commission to act on behalf of a regulated person? So many of you may recall that under the previous act, auditors were approved. They were approved as part of the approval process of the fund. Where this legislation is different is that this legislation requires the prior approval of the auditor. And so in short, really, when we were going through the process, you may recall year before last and last year, the Bahamas was gray listed with respect to our tax cooperation by the EU. And a part of the condition for that gray listing was that we had to satisfy the EU with respect to our funds regime. And so this was one of the issues that came up. And we, in order to meet the European standards and to avoid that blacklisting, we had to provide a satisfactory regulatory framework for the approval of auditors. I think though that you're likely to see something similar being achieved when we get to amending the SIA or overhauling the SIA this year. And so I think that you probably need to look at this type of framework as the way forward and not anything that would be novel, okay? So that really is the end of the big questions. Now, there are a number of smaller questions that we have. I mean, loads of smaller questions that we have, and I'm sure that the audience is eager to jump in there. And so I just want to say thank you, and I look forward to your questions, and hopefully we can have a very productive discussion.
Thank you, both Ms. Roll and Ms. Taylor. I know many of the queries that they received in advance were addressed just now by both of them, so thank you for that. I'm sure there's additional queries you have. You can either submit them through the Q&A feature, or if you want to ask your question directly, if you just raise your hand, we'll be able to unmute you and receive your query. So, Ms. Taylor, one of the issues that I think keeps arising is this new concept of the registration of investment managers, very, very new for industry. And you certainly touched on the registration process, but I wonder if the Securities Commission could give us a little more information on the ongoing requirements that you will expect from a registered investment fund manager. For example, in the legislation, there's certain provisions such as a prior approval for change of directors that I feel certain the Commission doesn't want to impose. But I wonder if we could just get some clarity on what the expectations will be for a registered investment fund manager.
Well, it's meant to be, is my mic on? It's meant to be a light touch regime and registration regime. There are some instances in the Act where the fund managers were caught up by virtue of the definition, I believe, of the regulated person. However, we are going to make some changes to that to carve out for fund managers so that really the only obligation that they will have is to provide the declaration. And for those fund managers where annual license fees are applicable, they would have to pay the annual license fees. So there will not be, there's no requirement for us to be notified of a change of a director or a CEO or approve those items. No, that's not going to be applicable.
Thank you. We have a question that we've received from Shauna Lee Monroe, again on the investment managers. I think it's going to be a hot topic for us because it is a new concept. But she says, good morning. Can a smart fund terminate its relationship with an investment manager and continue its operations?
Yes, it can. Yes, it can, but where they do appoint a fund manager, they then need to have that fund manager registered. And where there's no management taking place, depending on the type of smart fund it is, where there's no management being taken place, a fund manager will not need to be appointed if that's the way the fund proceeds.
Thank you. I hope that addresses that. Another query we've received is, are there any amendment requirements for custodians?
No.
I don't think we contemplate.
No, there are no.
No.
There are no amendments.
What do they mean when they say
Sure,
requirements?
so I'm not sure that I understand the question fully, but I don't think that we have any ongoing obligation
No,
for the custodian in the act at all.
no.
Yeah.
Legal counsel is confirming definitively no. Thank you. I think this question now relates to the independence requirements. Does the current independence policy prevent an employee of an investment fund manager who is not a director of the investment fund manager entity from being an operator or director of a fund?
Okay, hold on. Let me
Break
break this out. Okay, so you have someone who is an employee of a fund manager.
Just an employee, not a director.
Okay.
Would the independence policy prohibit that person from being an operator or director of a fund? So I guess we're looking to flesh out more exactly what the commission is looking at with the independence requirements.
I think the issue is actually addressed in section 75, and 75 says something about the entities need at least one director who is different. And so if there's one director who is different, I don't think you would have a problem there. Okay.
Thank you. We have another question from Lolita Bethel, and she says, good morning. Regarding extension requests for filing, since they are now limited to a maximum of 2, will the extension be given for longer periods?
No, not really. I think the issue, so the commission is still in finalizing that policy. As Megan alluded to, we had a consultation with BICA, but I think each extension request will have a maximum of up to 6 months. And so, in essence, the fund or any type of licensee will not be able to get extensions beyond a year of when the financials were originally due.
And for confirmation, I think there was some conflict between the Act and the regs as far as the amount of time before the audited financials have to be submitted. Can we just clarify, is that 4 months or 6 months?
So it's 4 months for an investment fund administrator and 6 months for an investment fund.
Okay, thank you. We have another question from,
We do have one clarification to make. One of the sections does conflict, so there is an amendment that's needed, just to clarify that to make sure that the periods provided throughout the legislation is consistent.
thank you.
Yeah.
I think that's why it's good we're receiving these queries now, so if there are amendments, we can pinpoint and hone in and address them all with the next sort of go-round. We've got another query from Kamika, and I apologize if I pronounce anybody's name wrong.
Kamika Roberts.
That's all I have. What is the Commission's position on investment funds that hold fixed assets and do not have an investment manager appointed?
Okay, so the position according to the legislation is that if it's a standard fund, it doesn't matter what assets it holds. A standard fund has to appoint an investment manager. Currently, as the legislation is written, a professional fund also has to appoint an investment manager, although there is some, there's some indication in the legislation that may not have been our intention, and so we probably will fix that. But as it stands, and a professional fund also has to appoint an investment manager. So this issue will only come up with respect to a smart fund. And so if a smart fund has not appointed its an investment manager, then its operators are responsible for the investments.
Okay, thank you. We have another query. I can't see who it's from. It's listed as anonymous. Does the investment fund manager require physical presence requirements under CESRA for investment management? If so, do they require a CEO and MLRO?
I think that they are included under CESRA.
Yes.
Whether they need an MLRO and a compliance officer, I'm not 100% sure of. Megan,
Yeah.
are you?
No,
aware?
they don't need a they don't have to have a compliance officer and MLRO, but where there is someone carrying out the functions, they should. Yeah. And in terms of CES,
Yeah, I think the issue comes up where an investment manager is trying to claim this jurisdiction.
right.
As for tax purposes. That's where the issue comes up. And so I think we had this circumstance before where we had these investment managers who are IBCs, and we still have the circumstance, and whether they fall under CESRA. And as Michelle indicated, they fall under CESRA. But the issue then comes up whether they're trying to claim the jurisdiction as a tax resident. And if they are, then yes, they will need a compliance officer and a CEO to meet the physical presence requirements. Now, if they're not trying to claim the jurisdiction, then that's a different matter.
Mm-hmm. Would you say that the Commission is giving guidance in this regard, or
So
telling people their best left looking at that relevant authority in CESRA?
So as long as I'm not going to be whipped for my honesty.
Or quoted?
So as long as I'm not going to be whipped for my honesty, I'll say that this is an issue that the Commission recognized about 1.5 years ago that we do need to develop some guidance on. So we do need to sort through these issues and develop some guidance on. I'm loath to give a timeline on that because I know what our schedule would be like this year. But I must say that this is an issue that we flag.
No, I'm pleased to hear that the Commission will offer guidance, because that brings me to another query that technically would be outside your scope, But since it affects your registrants and licensees, I'm glad the commission is there to lend a hand. But one of the queries was, can you clarify whether investment funds will be excluded from the imposition of capital gains, corporate or other taxes following the end of the transition period under the removal of Preferential Exemptions Act this year?
My legal counsel may
That does not fall within
You
the
guys are
purview
being
of
so
the
generous with
commission.
your help to registrants. I thought we'd
You know,
ask your
we-
views on this as
I
well.
think what we can do is undertake to speak with and clarify with Ministry of Finance on what is intended, look at it, and see if we can provide some clarification at another time. But I don't think that we're able to do that this morning.
But we can look to you, hopefully, to, I guess, be a conduit to helping the industry get some guidance
Once I get the directive from my executive director, sure.
on the spot.
Yes, certainly.
We have another query from Pamela Canaris. Good morning. What is the rationale for an investment fund being restricted to only suspending its activities without winding up within 1 year of licensing per section 22.1, if you
Sorry, I
have
didn't
it?
hear the question.
Do you want
Sorry,
me to
can
repeat
you-
it?
Yes, can you repeat?
What is the rationale for an investment fund being restricted to only suspending its activities without winding up within 1 year of licensing?
Yeah, I think Mr. Rowe.
No, I don't know that we intended that they can only suspend. I think maybe what we intended there is to give them the option to suspend without winding up. But if we're restricting them from winding up, certainly no, that's not our intention. So then that sounds like something we need to flag to fix.
I think this was a transfer of the dormant fund
Oh, I
concept
see.
that we
Yes.
had in the original legislation.
Yes.
So we changed dormant funds, the structure of dormant funds, into a concept of suspending your license so that we don't have this separation in categories between dormant funds. So you can voluntarily suspend. And I think that the rationale there may have been that we don't want people just hanging on forever before they actually.
Yeah, but the suspension should be an option, not.
Yes, it is an option in the
Yeah, it shouldn't-
voluntary.
It shouldn't be.
From
But
the
it doesn't
voluntary.
prohibit.
It shouldn't prohibit from winding up.
Right.
If the fund is at the point where they can already make that decision to wind up,
Then they need
then they should certainly go ahead and do that. So if there's something there that we need to fix, then I think we could flag that.
Yeah.
Okay, so we'll flag that as another thing probably to look at and clarify. We have another query. Are there physical presence requirements for a fund manager? I guess we distinguish. This is probably still focused on our lovely registered investment fund managers.
Currently,
Are there
no.
No, not
Currently,
for
no.
registration.
don't have any.
No.
So no physical presence requirements, and currently no regulatory capital requirements.
No.
No, because
So
we don't
we-
have licensed investment
Yeah, so
managers.
I
The
think
licensed
just to
investment
clarify that issue where Megan raised the currently, I think the issue only comes up in the case of funds, in the case of investment managers that were required to be licensed.
Right.
You know, we do have regulatory capital requirements under the Securities Industry Act, and we always ask ourselves the question, okay, so for someone in a prescribed jurisdiction, is that fair to them if they don't have to meet any? You know, whereas are they now at an advantage to fund managers who are registered and who are licensed under the Securities Industry Act? And maybe we thought that we should seek to balance that, but I think really the answer is no.
We've moved away from that. That's
Yeah.
pleasing to hear.
Yeah, the answer is no.
Another query from Mario Maldini is, good morning. Regarding auditor approval, is there a list of pre-approved auditors?
No,
No.
we
Okay,
don't have
we
this
don't have
approved.
No.
Is there conceptually, so with certain sort of category of auditors, one wouldn't have to seek pre-approval? Is there sort of something conceptually with the Securities Commission where,
So the only concept to that is that there have been circumstances where an auditor would like to receive a letter from the commission saying that we would approve them if they were submitted. And we've given such a letter to auditors.
Okay.
But we don't have a pre-approved list of auditors.
because I think historically it was an approval requirement, but there was sort of an understanding as to which auditors may trigger a need for actual formal approval. have we moved away from that completely, and every single auditor, no matter who, would require the approval?
I think the challenge in the legislation that we would have to figure out how to overcome is a requirement for prior approval of the auditor in relation to a fund. So we could potentially have a list where we recognize that certain auditors would be okay, but we'd still have to exercise some review or consideration of that auditor in relation to a particular fund. That could, I would imagine, Megan, you know, she could easily come up with something that's quite simple. I'm not, you know, I'm not overstepping. I'm staying in my lane. But yeah, I think that may be the challenge. But I'm sure we could practically overcome that.
So to give a practical example of what Michelle is talking about, if you know that an auditor is a one-man shop and they're trying to take on, you know, a $10 billion fund with all kind of complex assets, the commission may look at that and say, oh, whoa, this may not be appropriate here. You need some manpower behind you,
Okay.
you know?
While we're throwing things on Megan, our manager of supervision, a query that's come through is there any sort of confirmation as to when we'll see the new sort of forms for the application sort of and registration of the investment fund managers?
We're certainly, like Ms. Rose said, we're certainly looking for after summer to have all of the amendments to the investment funds regulations and the act sorted out, and then it's just up to legal and parliament to decide when.
I
But
think the
we're looking
forms,
for the
though,
third quarter.
Yeah, the form. There are some complication on the form. So some of those forms are embedded in the regulations,
Right.
Okay.
and so to change the forms, we would have to go to the minister and have the regs changed. So that's a part of the complication with changing the form. So we'll certainly have to address the forms when we address the amendments to the regs.
Okay, so there's the intention to revise the forms and issue guidance.
Yes.
But we won't see that until after the amendments
So
have
the
actually...
guidance will come out a lot earlier than
Yes.
that. In fact, probably next month, Megan and her team are completing what they called a UIFA booklet.
Okay.
And so
Exciting.
it'll give a lot of very good guidance on how the commission thinks through certain things, and I think it'll give a lot of details of what the expectations are.
So will we get sort of positions on aspects that will require amendment that haven't been amended yet, but just sort of, I guess,
So
the commission
I
stands?
think what we can do, and I could appreciate that the industry, especially those of you who have to answer questions and give legal opinions, would want a very clear written position on the commission. What we can do in that instance then is probably produce a short Q&A that we can publish and provide you the position of the commission on that.
Okay, thank
Okay?
you.
And I think that's something we can undertake to do.
No, I think we'd
fairly
look
quickly.
forward to that, so everyone's on the same page in industry. We have a query from Mr. Anton Bastian, and it looks like he is putting himself forward to suggest a new smart fund template, but he said, with the increase in private equity type structures, do you think 6 months is enough time to get proper valuations and audits? Do you think perhaps we need a new smart fund rule for private equity or venture capital funds?
Okay, so I mean, I would say, you know, if you're thinking that you want a new rule that will address something like that, let's just be sure first that we can accomplish it with the provisions as they now stand in the act. But I don't think that it's something that the commission is close to. What the commission would like you to address, though, is the principles of how reporting would be done in circumstances where you need to go outside of this 6 months. And so that is something, that's a conversation we can have, but that's something we would be open to as long as you're addressing certain principles.
Is the commission seeing a lot of requests for extensions already with this type of fund?
Not reporting extensions, hardly, not really.
They vary, depends.
Yeah.
On the difficulty in valuing the assets.
What we see a lot of are funds that have, I would say that assets that can't be priced. and that is a concern that we probably, so we see more than we'd like to see funds that have illiquid assets, you know.
Yeah.
All right. We have another question from Alexander Murbach. Please confirm that a professional fund who has 2 directors needs just one director to be independent from the fund's investment fund manager, but the second director can be an employee of the investment fund manager.
Yes, that's correct.
Okay.
I think that meets the deeming requirement
Yeah.
in Section 5. And just to piggyback,
She keeps saying
Subsection.
Section 76, sub 5. She got people going to Section 5.
only the lawyers will go to Section 5. You know, ordinary people know exactly what I talk
And email you.
Yeah. Ordinary people know exactly what I'm talking about. Okay, so to piggyback off that question, though, there was an issue that came up. There was an issue that came up on whether the operators and whether the operators of the fund needed to be, whether the operators and anyone all needed to have different directors. So, for example, if someone had an administrator who had an investment manager that shared the same directors, you know, whether all of the directors had to be independent of the other. And we found that question a little bit strange, but I think we saw where there was a problem created. I think the problem was created in Section 76, in Reg 76, Section 2, where we repeated the word operator, and so it gave this impression that even the underlying directors of all of these persons needed to be independent of each other. So the answer on that is no, they don't need to be independent of each other, the underlying, the directors. You know, by nature of their fiduciary responsibility, it is expected that the director is independent. And where you have this situation where at least one director is different, to deem the independence, you know, that is a different thing. But the commission does not see there being a lack of independence just because the directors are the same. Now, what we would admit is there may be some conflicts, but the conflict is not necessarily an independence issue. You know?
On the topic of directors of funds, and I know you spoke to focusing on corporate governance, is the Securities Commission considering limiting the number of funds that a director can act for, as we've seen in some other jurisdictions previously?
So that isn't a question that we've currently considered or benchmarked, but I mean, I think it's certainly, if the industry thinks it's warranted, it's something you can raise, but it wasn't something. But at the moment, we don't see, we probably have more concerns on the number of people who have the same outsourced MLRO. So far, we don't have a concern really on the director, but certainly we're starting to be concerned on the number of people who may have the same outsourced compliance officer and MLRO.
So should we
But
anticipate?
we don't see it so much on the directors.
Should we anticipate a restriction coming in that arena so people can be minded to that?
So I wouldn't call it a restriction as much as I would call it some guidance on it, because we do have to address the capacity issue, you know, but I guess we have to think through a framework that is sensible and that is appropriate. We do recognize that some entities have very little activity, and so you know, you can't say that someone with 500 clients is the same as someone who may be managing maybe just $2 million or something, you know.
So case by case, but fair to say, be cognizant.
But certainly a framework that will get us to a fair.
You'll look at capacity on a case by case. If I can just go back to some of the Q&As, apologies to Pamela Canaris, a clarification. Her question really related to the issue of a fund only being able to suspend within 1 year of licensing. So after that 1 year period, are they still able to suspend operations, or would it have to be a liquidation?
So the issue was whether they could be essentially dormant for more than a year.
Yeah.
And I think that our intention there was deliberate.
Yeah.
I think our intention there was deliberate, that they make a decision to wind up after that.
But after they've been in operation for more than a year, it's still an option to suspend and become dormant at a later date.
Yeah.
No?
No.
Currently,
I think
not as
you
in
have a,
legislation.
I think you have a limited time period before you must launch
Correct.
or wind up.
As well as the suspension. As it's currently written,
Yeah.
she's correct. You cannot apply for suspension. Let's just say if you've been in operation after a year, you can't, after 1 year of operation, you can't apply for suspension.
So that's
So I think
So
if we
it
go
may be
back
something that we
now,
have to look back.
is
look
what
back
is
at.
the
that.
rationale for that? Because that was always an
Yeah.
option. So what would be the rationale in not giving a fund the ability to suspend or be dormant after it's already been operational for a year?
For a year,
We have
I
to
don't
look
know.
at it.
I think we have to look at that because, to my mind, that doesn't go back to what we originally had with dormancy, and I don't remember trying to fix it to limit it. I know, like Ms. Rhodes says, we did say we only wanted dormancy or the suspension for a limited period. That is where the limit ought to have landed. But for Pamela, we'll certainly look at, we
For
need
it
to
to
look at that
extend
just to
further.
clarify what actually happened.
Okay, we have a query regarding the CEO/MLRO role for the fund manager.
That probably
And they ask, can that be outsourced to the investment fund administrator? So I guess if we break that up, one, is it a requirement for a registered investment fund manager to have a CEO and MLRO?
No.
Okay.
But where they do, we want them to confirm who the person is and who's carrying out the function of MLR as an MLRO.
And if they want someone to have that function, can that be outsourced to whomever, or,
Yes, there's nothing that prohibits it.
okay?
But you are going to create that substance issue for Cedra. Just saying.
We're waiting for your guidance, Executive Director. Your legal is looking at you wondering why you offered. But we're going to be
What is it we said? We're creatures of instruction.
we're going to be waiting for it. We're going to be waiting for it. Another query that came up, one of the provisions that I think is new is that every 3 years, unaudited financial statements will, for a fund, you'd need to have an accountant confirm that the unaudited financial statements have been maintained in accordance with the requirements in the Act.
Yes.
And how exactly does the Securities Commission plan on monitoring this and enforcing this?
Okay, so you're talking now about Regulation 75, I believe, right?
Yes.
Okay, and so the issue here is that Regulation 75, and this was another issue that came up, and actually, I could throw Antoine under the bus for this because this was
Don't do that, because he's here, and I'm gonna have to read his response.
I don't know if you
This
could
was
on
actually one of his direct recommendations because he was one of the people we called to talk through the issue because he has both an accounting background and a fund administration background. So he was like, oh, why don't you do it? And we said, oh, that's a good idea. And so
That's a big bus.
so what the requirement is here is that every 3 years, a qualified accountant must confirm that the books are being kept in accordance with IFRS or US GAAP. So we had actually a conversation about BICA on this issue. And so there is even a debate within BICA. So first, before I answer the question of how the Commission will monitor it, the short answer to your question on how the Commission will monitor it is the Commission will likely require a filing to be made with the Commission. That's how we will monitor it. Now, how will a licensee achieve this in a cost-effective way is really what we had the conversation with BICA about. Okay? And there's even a debate within BICA. There's a debate within BICA as to whether this requirement amounts to a full audit or not. You know, there are some members of BICA who believe that it does amount to a full audit. Other members believe that it doesn't amount to a full audit. However, certain procedures will have to be established as to how this takes place, how this confirmation takes place. The last, we left it with BICA, and I believe, I don't think he'll mind me calling his name out. I believe Phil Galanis had undertaken to spearhead this through with BICA to develop guidance for BICA members on how they establish protocols to achieve this confirmation. Okay.
Okay, thank you. So should industry consider that this may be something that's revised?
Not the requirement,
Right.
but what I think we're working with BICA to ensure that we can achieve it in a way that will not become burdensome or costly for funds.
Okay. So we have another query with regards to outsourcing. Will the Investment Funds Act be amended to include outsourcing requirements? If not, is there any guidance on outsourcing? And if so, how does the Commission view outsourced functions?
So I think we would need to know specifically what they want to outsource.
Yeah.
Generally, has the Commission sort of considered the outsourcing of any functions?
So a fiduciary will not be able to outsource. I mean, so what is it exactly that they want to outsource? Can a fund administrator outsource certain of their functions now? Yeah, they can. They can enter into SLAs with service providers, and provided that the Commission is satisfied that they're still able to meet their obligations, the Commission is likely to approve that SLA. So I don't know that there is something specific we need to address on outsourcing unless you let me know what the specific issue is.
I don't know if it could be with one of the functions. I know with investment fund administrators, they'd maybe sub-delegate. You would want to
Yeah, so
vet
they
that.
can do, yeah, they can.
With investment fund managers, you've now given the
Delegated.
very clear requirements.
Yeah.
And they
can
can delegate as well.
So I don't know if maybe they
They can
mean, will you flesh out where there's delegation of functions to another entity as to the requirements? In some instances, it's very clear.
Right.
I don't know if that could be the thought behind that question.
We have a very limited provision in the is it the SIA regs that deals with outsourcing standards and the requirements for outsourcing. So maybe something like that, but I don't see that for the IFA is particularly necessary.
I think that there are sufficient provisions with
Yeah.
respect to outsourcing. So unless there's a specific issue that we need to address on it, I'm not sure.
Well, perhaps, I mean, I did say, or I hope I said, if we don't get a chance to address anything now, the Commission is open to receiving any further queries after the fact. Another question we've received is, will there be any AML/CFT rules issued for the AFA license?
For the
IFA,
for
sorry.
the IFA licensee. So I think the IFA licensees currently fall under the SIA AML CFT rules.
They do.
So while we tried to make the IFA self-contained, there are still in a couple instances where provisions of the SIA apply to the IFA, and the SIA AML CFT rules apply to the IFA already. And I think most of the requirement with respect to AML CFT fall on the administrator, the operators, and other entities. Yeah. Now maybe we need to create some guidance on it, but the rules already apply.
I don't know if people feel there's need for further clarity. They'd feed through to yourselves.
I think any crossovers like that and any leftover confusion will be addressed when we look at revamping the SIA anyway. So we could tighten up those issues. unless something specific is raised from that perspective. But the, like Ms. Roll says, the SIA rules currently apply to the IFA.
A general query in relation to the principal office requirement with investment fund administrators. With the concept of the foreign investment fund administrator, there's no requirement for them to have a presence here. So what are the expectations from the Securities Commission with regards to where they, I guess, outsource, appoint a principal office in the Bahamas?
So I think, I know this is one point Pamela Canaris is always about to make an amendment to make it very clear that the principal office must be in the Bahamas. And I think that we've achieved that, but there's one clarification in a certain section that she's pointed out to us that needs clarification. So yes, the principal office must be in the Bahamas. I think the way the legislation is written, and Michelle could probably chime in if she remember. But I think the way it's written, a principal office can be an investment fund administrator, or I think another licensee of the commission. So it could be an FCSB, an SIA licensee, or someone else who is registered by the commission. But it must be a regulated entity, and that's our point. And it must be an entity that's regulated by the commission.
And in the Bahamas.
And in the Bahamas.
Yeah, I think, like Ms. Rose says, we have to make one clarification in one of the sections to ensure that we consistently show that it has to be in the Bahamas.
Yeah.
Okay. A general topic that Aaliyah Allen had raised that I don't think I've heard much mention on before, but what is the status of AIFM passporting?
Okay, so where we had a conversation, so some of you in the industry would know, especially people who participate to the BFSB funds working group, that, you know, the Securities Commission, we established a very good relationship with ESMA, which is the European Securities Market Authority. And we've been liaising with them for several years on the AIFM passport. Mm-hmm. Where it stood, we benchmarked which countries that were selected. We looked at how it seemed like some countries were selected in the first round and we were not selected in the first round. And it seems like the countries who were selected in the first round for passporting, they just had signed one more tier than we had. No, seriously, that's how it looked. That's how it looked, like they had signed one more tier with us. And I think in certain instances, there were specific countries that they had signed with, and there was one country we didn't sign with that we saw, that we said, oh, that may have been the factor there. But when we went through this journey of overhauling the legislation, we reached out to ESMA, and we provided them with copies of the draft legislation. We also provided them with copies of the promulgated legislation, and actually we got feedback directly from the head of ESMA. But the issue on their side is that the process has been suspended. And they said to us, I think the last communication, Shirin, who is responsible for our international coordination, the last communication she received is that when it resumes, you know, we'll likely be in that round, but their passporting process has not resumed. You know, from what I've seen from international meetings, I'm not entirely convinced that their passporting process will resume.
Okay.
But that's a different issue.
Okay, another query from Aaliyah Allen. Will you be publishing similar guidance to the Insurance Commission for fund managers captured by economic substance?
Yes, so that's the issue we addressed earlier,
Yes.
and we intend to.
Yeah.
Okay. Another query from Kamika. Regarding the registration of the investment manager, there were investment managers that acted on several funds, and a separate application along with relevant due diligence information on such investment manager had to be submitted to the Commission several times. Would this investment manager receive several registration, I guess, certificates?
I'm not sure I understand.
No.
So I'm wondering if it comes back to what I think we had touched on briefly before on this investment manager regime, where there is a requirement for an application with each fund.
Okay.
So perhaps the question is there a certificate issued to the investment manager with each fund they're registered in connection
yes,
with?
and it will likely remain that way. So this is not an SIA type registration where someone is a standalone investment manager under this act. You know, a standalone investment manager is registered under the Securities Industry Act. And so if they want to be licensed as a standalone investment manager, that is the place to go. So in this act, they would be attached to a fund. Now, we still have to address the issue of whether we would provide a pre-registration process. But I don't see that pre-registration process involving a certificate.
Okay.
You know.
Should industry anticipate, I guess, so numerous certificates for each fund, and then what sort of reporting obligations and annual filings would be connected with each certificate, or would the investment fund manager be doing one filing and perhaps a listing to you?
So the investment fund manager will likely, as Megan said, have to make an annual declaration. That's the biggest thing we see so far. And that will probably, that's something like, you know, we're managing the fund in accordance with the OM, we're doing certain things. That would be on the fund level.
Okay, so no annual declaration.
So we're not trying to regulate the investment manager itself. We're trying to have oversight of the investment manager's activity in relation to the fund that they manage, right?
Okay. So I think we'll welcome the guidance generally on this very new area for all of us with the registration and I guess the ongoing requirements for investment fund managers.
Yeah.
We have another query in from Lyndon Dean. Has the commission considered a SPAC-like fund?
What is the
I don't know,
SPAC-like
yeah.
fund?
What is that?
Sorry, I don't know that acronym.
I'm simply the moderator. Or perhaps Lyndon Dean can send some clarification in for us on that.
Specifically.
I don't know what an SPAC fund is.
We have another query here, but I think we've addressed it. When will confirmation of approval of application or registration of the managers be issued? So I don't know if they're talking about the perhaps turnaround time. When will confirmation of approval of the application or registration of investment managers be issued?
Okay, so we did experience a backlog because we were restricted
I'm
in
sure.
terms of COVID, and we did have a lot of applications that came in, and we required some clarifications. But I anticipate that all of the applications all of the existing applications will be dealt with by, I would say, the end of April. There are just a few items. There are just a few approval in principles or last set that are lingering. But I think they'll be done around April. The turnaround time, once we're done with the 439 applications, I believe it is. The turnaround time, we expect to be between 7 and 14 days, because we anticipate that, you know, with this new regime, we had to register everyone. But as funds come in, we won't see that much happening. And so we anticipate a quick turnaround of 7 to 14 days.
Someone has
And
asked,
a lot of the fund managers will be known to us. So I think in relation to Kamika's question, where a person is already known to us and we have due diligence on them already, they've been registered for a fund, minimum due diligence will be, can be provided with the application, but we will want another application form. They'll have to pay application fees. And just a small issue, the legislation does contemplate a certificate, and I think the declaration does as well. We decided not to go with certificates.
so what should an
But there will
applicant
be
expect?
an approval letter for the registration, right? So we will
Oh, that's
confirm.
right, that's
Yeah, so
right.
we will confirm by letter that
remember
you are registered to
Glad we
act
have everybody here.
as investment fund manager for X, Y, and Z funds. And we will also publish a list on the website next to the funds. To the current listing that we do now, we will have the registered fund manager next to the fund. And so there'll be an ongoing list where persons can confirm that this fund manager is registered for a fund.
Okay.
Okay, and another general query and related to this as well is whether the Securities Commission will issue a checklist, sort of, I guess, an application checklist to ensure that there's no back and forth and everyone's clear on exactly what's required.
Yes, there'll be a fund manager. I don't think that we ever issued a public checklist. We certainly sent out the Regulation 22 matrix to persons because I think it was being missed initially with the applications. But it will be in the UFA booklet, and we should be doing a fund manager guidance to be published, I would say, by the end of the month, by the end of April. Not the end of this month, the end of April.
So we'll call you. So I think some of the key things that I'm reading here and from the questions you all had received previously is, I guess, really looking for clarity on this independence situation, which you've spoken to in some depth, and I guess we're hopeful to see more guidance on that as well. Certainly with the registration of investment fund managers, the process and I guess ongoing requirements, and then as well with the foreign investment fund administrators, all very new concepts. Will we, with the investment fund administrators, I know, Ms. Roll, you had spoken to certain of the requirements not being necessary that we currently see in the legislation. Can we anticipate a policy position paper from the Securities Commission now as opposed to waiting until the legislation is amended?
Yes, we can do that. So what we can undertake to do is probably put out those policy positions certainly by the end of next quarter, and possibly sooner. But I would say by the end of next quarter could be the hard deadline. I think the only caveat to that is that what we would like to see happen is, we do have to make some additional amendments to the legislation in terms of both the Act and the regs that we've already referred to. And so our intention is to get additional feedback from the industry. And we're hoping to open it up for probably another 30 days or so to get any additional feedback on things we either need to address or things we need to change. And once we get all of that feedback, then we could address the policy guidance. And so that's really making sure that we're covering all of the issues. And then I would say by the end of the summer, we'd make all of the changes. And also our aim is, once we've made the necessary changes, is to have a consolidated version of both the Act and the reg.
Oh, that would be welcomed. Back to this outsourcing issue, we just got clarification. Outsourcing of back office, HR, IT. So I guess with a regulated entity, does the Commission have any issue with outsourcing of internal functions of that entity?
No, we do not.
Okay, and that's not something you foresee?
So that is something that the entity usually handled through an SLA. Now, so they would file the SLA with the Commission. I was going to complicate things, but let's just leave it as just file the SLA with the Commission. The Commission would say whether there is an objection to the SLA or not.
Okay.
So the thing I was going to say is that there are some functions that we do not see as within our regulatory remit. And so if an entity outsourced those functions, really the matter isn't coming before the Commission. But I would say, to be on the safe side, it's probably safer for the entity to just file the SLA with the Commission, because you don't want to be caught in a circumstance where we come to inspect you, you have an SLA that should have been filed with us and it wasn't. That's not a good situation to be in.
So to avoid sort of, I guess, confusion there, you would say for now be guided by the outsourcing guidelines under the SIA?
Yes, I guess you can be.
Any material functions?
Material functions. So material functions, there's a debate whether HR is considered a material function, for example.
I would say yes in our office. Most places, but perhaps not in these, for the regulator's purview, perhaps not. this is similar to what I think we've already gone over. Again, Megan, you are loved deeply. Really, I guess pushing for the, I guess, time frames. You've already addressed it. Time frames on the investment fund manager registrations and receipt of those approval letters. But you've touched
Yeah,
on.
I think I can see on the screen something about a confirmation. If an application is not acknowledged.
She's younger than us. I am now having to face my age, and I need reading glasses, and
If
you're
an
making this public for me now.
Yeah, if an application has not been confirmed as received, just please send a note to supervision@scb.gov.bs or to myself so that we can confirm that we received the application. There may have been an issue with the size or something. So if they've not received a confirmation, I think that's what the question is if they're awaiting a response.
I think for the approval letter, but they perhaps haven't received anything at all. So you would suggest just a follow-up from their
Just to ensure,
application
right,
to ensure
yeah,
that it's been
yeah,
received, because
yeah.
you got 400 and something. So just to make sure they.
We're almost done. We're seeing our way through, so we're almost done.
Okay. This is a question I think you've touched on that you'll offer guidance, but do foreign fund investment managers who claim the Bahamas as their tax jurisdiction need to be registered and licensed by the Securities Commission? And if so, must meet regulatory capital requirements?
So they certainly would have to meet
Should
the
be under that,
substance
Requirement.
requirement.
Yes, I think this is probably twofold.
Yeah.
Either you're licensed and you meet those regulatory capital
Yeah.
requirements, or you're
Meeting-
registered and you've clarified
Right.
no regulatory capital requirements.
No. But you would have to
But
meet substance
that
requirements.
doesn't remove you from analyzing how you would fall under CESRA.
That's right, right.
And if indeed you would be incorporated here. So I think to look at that legislation separately and see what you trigger there.
Yeah.
We've got another query. What is the administrator's obligation regarding the investment manager's registration? How can an administrator become aware that an investment manager has been duly registered or if registration has been denied? This is from Caroline Sampaio.
So I don't know that the administrator has an obligation with respect to the investment manager's registration.
Yeah.
I mean, certainly I think, though,
think we were
that
supposed
if
to
you
remove something.
are
There's a
going to be
little-
the
there's a little
administrator
trend.
of a fund, you have a right to make the query of the operator.
Yeah.
You know, and you're entitled to that disclosure from the operator.
I think
but
this is
certainly,
For
I think
guidance,
this is a layover from the
From the old
previous
act,
act
yeah.
and the obligations that the administrator had there to make sure that everybody was properly regulated and that the fund had done everything that it needed to do. Those obligations have now been right-sized and put on the operator,
yeah.
who has to ensure that everything for the fund is in order. And the administrator really is only responsible for administering the fund. But I think, Ms. Rowe, that the answer is right. If you're going to be the administrator, you obviously have a right to ask.
The operator. If
the
someone
I guess in
operator.
this gap period, sort of acknowledging that you would have received so many applications days before November 30th.
Okay, I see.
And you
I see
may be in the
the
process
question.
of setting up a fund. Guidance for an administrator, right now, do you think it would be
So I think-
sufficient for the administrator to move forward with a copy of the application?
I think the backlog is only existing for, it's only for existing funds.
Right, yeah.
Backlog that Megan refers to.
Okay.
Yeah, yeah.
For new funds that are being set up, the investment manager is being approved alongside the fund. And so I think that is being done in normal timelines. But in terms of existing funds, there is a backlog that is created, and that backlog will be addressed before the end of this month. But if there is an application that someone has submitted, they certainly can call into the commission and get an update on the status.
And a status and expected turnaround time.
Yeah.
Right, and the fund administrator doesn't necessarily have to make the application. Investment manager can make the registration application for themselves if they need to send the information themselves, or they can work together to do so. Or an attorney can act on behalf of the fund administrator, and the fund manager for registration and licensing whatever may need to be done.
Okay.
So I think there's just a small amendment that we are looking at in the regulations where I think it says that the fund manager shall provide filings on the custodian and the fund manager, but we're going to make that change to the obligations of the fund administrator.
Oh.
Yeah.
Okay, just to clarify that.
Yes,
Yeah,
it's
there
in the
was one-
regulations and the
yeah, There
duties.
was one obligation that still had sort of a fiduciary feel to it, and we're just going to clean that up and move that from under the administrator to to be properly placed under the operator,
Yeah.
or the manager, I think it was.
Yeah.
Okay, we have a final question. Good morning. Can you speak to the possible conflicts and recommend resolution for a director with an employee as a separate director as well?
I thought you spoke.
So I would say, I would say, okay, to speak to the possible conflicts is probably a little bit complex.
Yeah.
Right? I would say that that's something we probably should provide some guidance on. Yeah, I would say that's something we could possibly provide some guidance on.
So sort of, I guess, encompassed under your general sort of guidance and fleshing out the
So I don't
expectations
think
on
that it's going
independence.
to appear in the UIFA guidance that Megan is putting out now, but certainly the first step we have to address is the circumstances under which an investment fund administrator can exempt the fund from the independence requirement. So, and tied into that is then probably some guidance that is needed tied into that on these issues of where all of these directors are appearing and they may be the same.
Right.
Yeah.
We have a question from Lakeisha Roll. This is on the investment manager as well, but a good point. Once an investment manager has already been registered, when applying for an additional registration, will a copy of the approval letter they've received in connection to another fund, I guess from a due diligence perspective, suffice? And then I guess just the template with the additional information on the new fund? Or will you be looking for full applications each time?
Sorry, a copy of the previous approval letter?
So if an investment fund manager's already been registered in connection with one fund and you've issued the approval letter, should they then apply to be registered as investment manager for another fund? Instead of submitting all of the due diligence again, will a copy of that approval letter you issued?
Yeah, so in terms of their utility bill or their professional qualifications, they won't need to submit that again. Just the police record, if we have an outdated police record,
Yeah.
they may have to provide
I think
that.
the question though is, do they have to submit the application
Vacation
form?
again, yeah.
And I guess
That's
the
a
short
question,
answer there is
yeah.
yes.
Yeah.
I would guess
Until-
the form and the regulation.
form and
Right,
any-
the
any-
regulation
any-
22 and the management agreement with that new fund as well.
Okay, so more approval letter than the documents required specific to their connection to this new fund.
Right, or with a cover letter, they can just advise us we were previously registered. I mean, we'll have it in our system that they're
Will this be covered in the
previously
guidance
registered.
you issued to industry?
I mean, we said, a lot of people like to say who was previously known to the commission, and that's sufficient at times.
I think the short answer there is that, well, I guess what I'm hearing there may be a need for is for us to take a look at a streamlined form in cases of a
Previously
pre-existing
registered.
licensee.
That's a good idea.
But the issue is that the application is attached to the fund. And so maybe we look at a very streamlined application when someone is pre-existing. And so that may be where the need lies.
And in relation to funds licensed by an unrestricted investment fund administrator, would you expect them to wait for the investment manager to be able to produce the approval letter before licensing the fund?
Well, we expect for a UIFA to do all of its due diligence before licensing the fund. They will not have to do a pre-registration, or they can do a pre-registration, or they can send in the fund manager registration. But all of the information that they would submit when they give us the licensing of the fund, because they're allowed to license, they can submit the due diligence for the fund manager as well as the application form. And we'll turn that around quickly so that we say that the investment manager is approved, they're registered for that fund. But they don't have to do it beforehand. They can submit that with the fund licensing that they have the 30 days to do, to submit to us.
I guess that's why everyone's pushing on the timeline. if they gamble and license based on the application being submitted, will they get caught in 30 days?
But all of our UFAs are supposed to do the due diligence. We've delegated that to them, and so they ought to act as we expect them to revise all of the due diligence of all of the service providers to the fund.
Okay, many accolades for the hard work you're doing, Megan, and your baptism by fire. I think everyone in industry can speak to that, especially since the numerous emails and calls you get in trying to especially get clarity on this new registration process. So thank you again. So I think industry generally is very appreciative to the Securities Commission for putting this together and hosting this and addressing a lot of the concerns and things we needed clarification on since implementing this new legislation. And we look forward to receiving sort of guidance, notes, and any new applications or forms that have been more sort of streamlined to help us. And Christina, just to confirm, did you indicate for those whose questions weren't addressed today or do have further issues that they'd want clarified or addressed by the Commission to submit those queries within 30 days of
Yeah, so I would like it submitted within 30 days, and really the cutoff is really to also apply a little bit of pressure so that we don't be lingering too long, because so far we've committed to putting out some revisions to the regs and the act by this summer, and so we also need a time to address those, and so we would have to consider all of the issues that come up, and then certainly we will address the policy issues in a publication for the Commission. After the 30-day period, I would say that we could address that probably within another month to 6 weeks.
We would hope to see the new draft out for consultation.
Yes.
Mm-hmm. Okay, so I'd encourage everyone to submit either the big issues, I think many of which we touched on and clarified today, or the smaller issues just requiring clarification where there's still probably some conflicts between different amended versions of legislation. But again, I want to thank you all. Michelle Martinburg, Senior Legal Counsel, here to make sure we stay honest. Megan Taylor, Head of Supervision, thank you for being here and you're surviving your baptism under fire by industry. And Executive Director Christina Roll for always being very candid and frank and guiding us through with what we can expect from the Commission and being very open to receiving industry's input. So thank you all, and thank you everyone for joining us today and for your questions as well. Thank you.
Thank you.
Thank you.